Justice LaBelle, members of the Court. My name is Mark Gelowitz, and I'm here with my colleague Gerard Kennedy on behalf of the intervener, the Canadian Constitution Foundation. My submissions in the appeal today are limited to the constitutional questions that have been stated by the Chief Justice. First, does the involuntary disclosure of personal home contact information to a bargaining agent infringe Section 2D of the Charter? We say that it does. Second, is that infringement justified under Section 1 of the Charter? And we say that it is not. On Section 2D, since the time of the Levine decision in 1991, this Court has recognized that the freedom to associate includes within it the freedom not to associate. In the key decisions, both Levine and Advance Cutting, the Court has been, it's fair to say, somewhat divided on the scope of the freedom not to associate and the underlying rationale for that freedom. And this case is an opportunity for the Court to harmonize the voices in those decisions. In brief, it's my submission that Justice Laforêt had it right in Levine. The freedom not to associate certainly includes protection from forced ideological conformity. But I say that it, as Justice Laforêt did, that it extends beyond protection from forced ideological conformity. The freedom not to associate and its underlying rationale extends to the protection of other charter values, core charter values, when those values are threatened by a form of forced association. In other words, the freedom not to associate carries with it the freedom not to have one's constitutional rights and liberty interests impaired by forced association. And one of those core values is privacy. One of those core rights and liberty interests is privacy. The protection of an individual's privacy is at the heart of both Section 7 and Section 8 of the Charter. This Court has held that respect for individual privacy is an essential component of what it means to be free. Infringement of the right to privacy is an impairment of an individual's liberty in a free and democratic society. I say that the rationale for the right to privacy is not far removed at all from the rationale for freedom of association. The right to privacy protects dignity, liberty, and autonomy, recognizing that an individual is entitled to a sphere where others are not to intrude without her consent. This is very much like freedom of association, which protects an individual's autonomy and liberty to decide whom, if anyone, she wishes to cooperate and interact with to achieve her own self-actualization, certainly when outside the workplace, certainly when in the privacy of her own home.
Does it boil down to really a right to be left alone? Is that what you're
It does, Justice Cromwell. I agree.
So that being sentenced to penitentiary would violate Section 2D subject to Section 1? Because you're having to associate with a bunch of criminals you don't want to associate with? I mean, where would that...
Well, there's a whole bunch of other charter rights that come into play when you've got
you would
machinery of the state coming down.
You would cast it that broadly so that there would be a limitation of 2D any time there was any relationship with another person imposed on you.
Well, I guess, Justice Cromwell, I would say that when the government acts to impose an individual into an associative relationship, the freedom not to associate is engaged. In different circumstances, that freedom not to associate will be either more or less susceptible to a Section 1 analysis. What we have here is not a criminal being placed into a corral with other criminals. What we have here is a governmental infliction of a governmental facilitation of ideological infliction of views with a party who the individual has made very clear she does not wish to associate.
Just trying to test the limits of your proposition, that's all. I'm not suggesting that there's any element of that nature here whatsoever. I'm just trying to struggle, though, with the breadth. in which you're casting this.
I understand. In this case, though, what we have is an intersection of the freedom not to associate and the engagement of the right to privacy. The non-consensual transmission of private information does a number of things. It first provides the union, with whom she does not wish to associate, with personal data about her that she does not wish them to have. And it enables the union, in possession of that information, to intrude into her private space to try to communicate with her against her will about things that she does not wish to hear. In my submission, any such employee ought to be able to say no to that, and as a constitutional matter, not have that refusal countermanded by government action. In order for the freedom not to associate to provide its full measure of protection, it must extend to allowing a person to withhold private information from a party with whom they do not wish to associate, and to block the unwanted infliction in a private setting of opinions, views, and ideologies from a party with whom they do not wish to associate. Turning then to Section 1 of the Charter, I appear to be one of a relatively small contingent suggesting that you can and should undertake the Section 1 analysis. As a preliminary point on the context of the Section 1 aspect of this case, it's important to observe, as has been pointed out previously, that this is not a case in which Parliament has deliberated about enacting the Charter violation at issue here. Parliament has not stated in any Act of Parliament that disclosure of private home contact information is meant to be mandatory under the legislation. To use the words of my friend, Counsel for the Attorney General, in her factum, there has been no complex and delicate balancing of interests by Parliament in respect of this issue. And as a result of that, it's not an instance in which this Court ought to grant any particular deference to Parliament in considering Section 1. My submissions on the inquiries required under Section 1 are limited to minimal impairment and the balancing of the salutary benefits versus deleterious effects. With respect to minimal impairment, you will have seen in the materials that a host of alternatives to mandatory disclosure have been proposed, such as an opt-out system or such as the union just getting it for themselves. In the face of such alternatives, for which no satisfactory answer has been provided in my submission, it's difficult to conceive of how the minimal impairment test could be satisfied in these circumstances. On the balancing of salutary benefits and deleterious effects, I make the following observations. On a macro level, the respondents and some of the interveners have concentrated on the alleged salutary benefits of collective bargaining in general. But in this analysis, we're not concerned with the salutary benefits of collective bargaining regime as a whole, just with the salutary benefits, if any, of the provision of this personal information. On a more practical level, everyone agrees before you that an individual is free to ignore a phone call or throw away a letter. As a matter of common sense, therefore, I say, it's difficult to see what salutary benefit comes to the union from having home contact information of an individual who will hang up the phone or throw away their letter. The deleterious effects, on the other hand, are profound. First, the right to privacy is violated. Mature adult workers are not allowed to decide with whom they will associate outside the workplace. Their legitimate desire to leave work at work is undermined. Most seriously, there's a risk of harassment to dissenting employees when labor relations go awry. Whatever the motivation the union may have to prevent abuse of private information on a day-to-day basis, the history of organized labor in Canada shows that in the context of labor strife, all bets are off. And when dissenting employees are harassed, those effects are nothing short of traumatic for the victimized individual. for privacy, property, and personal security are all in play. And the benefits to the union?
Well,
Slightly more
your time is over.
It is. Thank you,
Mr.
Gerard.
Gelowitz. Thank you very much.